for fixing a date, my lord, because the person is out of employment, my lord, for last 10 years. And twice he approached the learned tribunal, my lord, merely to tribunal pass and consideration order, my lord. Any day, your lordship, subject to lordship's itinerary permits, my lord.
Prioritization, sir, you are not alone.
No, but he's suffering the right to life, my lord. Last 10 years he's been...
That is why we said you are not alone. You give, see, 213, at least it's on the list. Click up, yes. For inclusions, you need not mention, give the slips. All the inclusions.
Malad, under compelling circumstances, I'm mentioning Malad one for judgment, Malad. Malad, hearing was concluded on 29th of July 2024, Malad. Malad, FAT 536 of 2028, Malad. I'm for the private respondent, Malad. Opposite party. Malad, this Malad.
Malad, permitted.
My lord, may I permitted to mention, my lord, petitioner asks.
Sir, no prioritization.
My lord, may I permitted to mention, my lord, petitioners are old age people, senior citizen, and I am challenging the order of CAT. They are challenging the order of the CAT for pension matters. The petitioner is they have not specially fixed the time period.
Well, permit to mention on hearing matter 2018 matter, Malad, the petitioner will declare. But pay fixation matter. But 2018, Malad,
My lord, may I permitted to mention one matter for inclusion in the list, my lord.
My lord, for restoration application.
Malads, at the cost of being reprimanded, may I be permitted to mention a writ appeal in the original side, Malads? The matter was fixed for consideration on the 18th of January at 2 p.m. Malads. My leader in the matter, Mr. S.N. Mukherjee, senior advocate, is in some difficulty on the 18th. Hence, I was praying for some 18th of February. So, hence, I was praying. Yes, I have served the other side. No. Malad, the understanding was that the consecutive dates of hearing would be heard. Both sides, I don't have those dates, Malads, but I've got the dates available, convenient dates of my leader.
Directed to be listed on a motion, on a mentioning being done.
No, the matter was taken up on the 30th of January, and then it was fixed on an understanding between the parties that the matter would be consecutively taken up on the 18th.
There's an order that will come on 18th. Then you mention on 18th. Why are you mentioning today? You mentioned that day. Don't worry.
Well,
Your Lordship, kindly, Malad, this is extreme urgent.
Before you mention, it will be better if you have a consensus on the next day to be fixed so that we can.
Malads, we've internally spoken and then put in the notice. Deeply.
Lordship, leave, my lord. I want to mention this matter. It's an extremely urgent matter, my lord. An examination is going to be held on 18th of February. My lord, my candidature was cancelled on 4th of February. My lord, I made an application before the authorities. My lord, thereafter, I approached the learned West Bengal Administrative Tribunal on 12th. I mentioned the matter on 12th. But unfortunately, my lord, the tribunal, because of its own, my lord, the things are there. The tribunal fixed the matter on 27th, thereby making my entire application infructuous, my lord. What I'm beseeching before Lordship, my lord, kindly leave may be granted to file this application on an AST matter.
What is going to happen on 18th? What is the next date? What did you say?
Well, the tribunal has given a date, my lord, on 27th. The examination is on 18th.
Examination. So you have not been allowed to
No, my lord, my candidature was cancelled on the pretext that a chance certificate was issued where the memo number is not there. But on the same plea, others were allowed. Well, this is a peculiar case, my lord. AST may be granted, my lord.
On Monday it will come. You have got the certified copy.
My lord, I mentioned the matter, my lord. Matter was never heard by the tribunal. I filed it on 12th. I mentioned it on 12th. My lord, the learned tribunal, my lord.
Certified copy হবে না এটা দিয়ে দাও হয়ে গেছে মানডে তাহলে এটা 12:30 আসতে
Can you serve the notice?
My lord, I will today itself, I will serve the notice on the government reader.
We'll take it up on Monday itself.
As a lordship, my lord, this is the filing date. My lord, this is the mentioning slip. I've annexed with the original application, writ petition. My lord, AST we granted, my lord, and without any orders, my lord, unless my lord, the registry of this court, my lord, unless your lordship grants me leave, my lord, the registry, there is no order we won't allow.
There is no order.
No order, my lord. That's because, my lord, it was filed on 12th. My lord, this is the slip I've annexed with the writ petition. And, my lord, this is the mentioning slip with the Knowledge Tribunal gives with a remark, my lord, matter to appear on 27th June.
Give it.
Diplomacy.
Please serve notice, ask them to be the state, whoever it is, so that when we take it up, somebody is there on the other side.
My lord, can it be at Monday at 2 p.m.? As because Monday 2 p.m.
My lord, may I be permitted to mention item number 146 for upgradation, my lord. My lord, I was before your lordship on Tuesday, my lord. Your lordship asked me to wait till Friday, my lord. On 17th, my lord, there is a contempt application to be taken before the tribunal, and they will attach the salary of my officer, my lord.
The direction, which tribunal?
Central Administrative Tribunal, my lord.
The direction.
For compliance of the original application's order, my lord.
Obviously, what is the direction we are asking you?
My lord, there is an order, my lord, that a divorced daughter, my lord, who she applied for the family pension after the death of the pensioners, my lord. That order, for the compliance of that order, my lord.
What is happening on the next date?
My lord, they'll attach my salary for non-compliance, for not giving the pension, my lord.
Where is the last order? Show us.
My lord, here I don't have the order.
Show us on Monday. When was the contempt file? How so soon there can be an order?
My lord, actually the issue is, my lord, original application was filed in 2008, my lord.
We have understood, sir. We are trying to understand what is the grave urgency in the contempt proceedings. When the contempt proceedings was filed, that it has reached the stage of attachment of your salary and you are here now.
My lord, give me 1 minute, my lord. I'll explain your lordship
to your lord. Petition of 25.
My lord.
So how can it travel?
My lord, the contempt application was pending since 2011. We had come before a writ court, my lord, before this high court, my lord. After that writ court, there was a direction to pass a reason order, my lord. We passed a reason order, but the tribunal has invoked the contempt application instead of directing them to file a fresh original application, my lord. And the pending contempt application, they have invoked the pending contempt application and have passed the order, my lord.
For payment?
For payment, my lord. I'm sorry, my lord, it is not contempt, MA application for execution of the order. I may be corrected, my lord, MA application.
Why do you wait till the last to file a writ petition and then you mention?
My lord, the order is passed on 6th January, my lord, in the MA application.
Attaching the salary.
For attaching the salary.
So where is the order? We want to see.
My lord, I have attached in my application, my lord.
You show us a copy. You mention after post recess.
I'm grateful, my lord. Yes. I'm grateful.
Call the list.
Item number 1.
My lord, item number 1.
This
matter was running in the list yesterday, my lord, under the heading adjourned motion, item number 33, my lord. Certainly came up under the as item number 1, my lord. My lord, learned additional solicitor general is assisting your lordship.
It was practically the learned additional solicitor general concluded his argument. Prior to that, Mr. Sushmita Sahadatto concluded his argument. Then written notes have been handed over. I was making the submission, my lord. Then my lord said that come with the notes as well as to show the entire thing. That was the situation. Today I have come with the, my lord, written notes and submission. Your lord, so kindly hear me.
My lord, we have not submitted any written notes of argument, my lord.
Yes, that the copy has been served upon me.
Written notes of argument, my lord.
Yes.
Is short note, my lord, kindly adjourn for 1 week, my lord. Kindly.
But this is the note, my lord. I received it on 15th of January.
There, my lord.
Yes.
I pay before your lordship only 1 week time, my lord. Kindly fix after 21st any day, my lord.
It's a settled position, my lord. This is but this issue practically May I hand over this, my lord, this short notes, my lord, for my lord's convenience. The brief fact is this, my lord. Petitioners, my lord, joined in postal department as time scale, my lord, postal assistant, my lord, or sorting assistant on diverse date, my lord, during the period 1980 to 1986. The scale of pay such and such. Then my scale of pay was revised during fourth CPC with effect from 1186 as 975, my lord, to 1660. The scale of pay was further revised to 4,000 to 6,000 during fifth CPC with effect from 91196. The petitioners, my lord, got transferred under Rule 38 of Postal Manual, my lord, as LDC, my lord, in 1990-92 on diverse date, my lord, with the protection of pay. Under third CPC, my lord, the scale of pay was that, and fourth CPC was that, my lord, the scale of pay was fixed accordingly, my lord. The petitioners got promotion as junior accountant during the period, my lord, 93 to 96. And the scale, my lord, what happened? The scale of pay of the entry cadre, my lord, and the scale of pay of the promotional post of junior accountant were fixed in one pay scale, that is 4,000 to 6,000, my lord, with effect from 1196. First financial upgradation under ACP scheme to the higher scale of pay of rupees 5,000 to 8,000 was granted with effect from 9/8/99, ignoring the promotion between the entry cadre and the promotional post dated such and such. Since, my lord, the scale was merged, my lord, the promotion became inconsequential. Your lordship will kindly see, I have annexed one statement, my lord, that they are from, my lord, will find. In my statement, my lord, I have given.
Neither parties were appearing before the tribunal.
No, no one could remain present, my lord, on the day of hearing.
Has to be considered by the tribunal.
My lord, 7 except 1 or 2, my lord, all have retired by now.
Done when the council chooses not to appear.
No, not chosen, my lord. Because of his illness, my lord, he could not appear. And the learned tribunal, in fact, my lord, did not grant any accommodation.
Have had sufficient experience on that side.
No. Yes, I know, my lord. I know. But
Therefore,
it was there.
If I am unable to go, I will ask some colleague or friend to
Yes,
make a mention.
that was asked for. That was asked for.
Nothing in the
My lord, problem is, my lord will find the name. The learned member.
Tribunal's order does not speak of any prayer
Right.
or adjournment.
Absolutely,
And
absolutely.
the order cannot be challenged on that ground that it has not
No,
recorded.
I have not challenged on that ground.
Because you were absent
Yes.
and you.
I'm accepting that. I'm accepting that. But the bare fact is this: since there was no indication, I didn't say so. Though it was intimated to me, I didn't say that because adjournment was prayed for, no adjournment was granted. I have taken no such averment.
No, you cannot.
No, I have not.
The law is that you cannot.
Yes.
Even if you say, we will not accept.
Yes. But the bare fact, what I have submitted, it's a bare fact. Be that as it may, my lord, I have said that it was not represented, the petitioners were not represented.
Neither parties were there, nor you were there, nor the respondent. The tribunal has on its own passed the order.
Yes, my lord. It is the position, my lord. Your lordship will kindly see, it was hard on one day.
Please see the impugned order, sir. Please read the impugned
Yes,
order.
yes. Both were recorded as none.
Not only that, in the body also we don't find that there is any mention. The tribunal is only referring to the pleadings and passing the.
Your lordship will finally kindly take one note. Hard on 30th of March 2012. That has been recorded. On that day, my lord, both parties presumably were present.
So it is to be considered as a judgment on hearing.
No, I'm not saying that. I'm not saying.
Does not mean anything. You are pointing out something which means nothing. That's why we are asking.
As my lord pleases, my lord, only thing I can submit that most of the petitioners have retired, my lord, and possibly one of them have died. One of them have died by now. Now it's entirely up to my lord's majesty, my lord, and magnanimity.
We have actually it is
no
only no order of the tribunal.
Only thing is your lordship, keeping apart this point for the time being, my lord. Only thing your lordship will kindly consider the same issue. The respondents before the learned tribunal relied upon a judgment of Bangalore bench CAT. And my lord, thereafter, my lord, in Chandigarh bench, on the same issue, the Bangalore bench differs from this case, not on that point.
When you don't argue your case, what do you expect the forum to do? When you don't argue your case, forum ought to have dismissed it in default.
My lord, there was no occasion to place the Chandigarh bench judgment or Punjab and Haryana High Court judgment, or that the Supreme Court has dismissed the.
Okay.
And this issue has set at rest. Inasmuch as the impugned memo, by virtue of all of them, were treated like this, that was set aside and passed. Now it's entirely up to my lords, my lord.
You had sought a transfer to a lower post.
No, not lower post. We sought voluntary transfer, my lord. It was transferred, my lord, and we were appointed there as LDC, my lord, with protection of
LDC from?
LDC, my lord, time scale postal assistant or sorting assistant.
At the time you requested for the transfer, you were posted as
LDC.
LDC.
Yes.
And you were transferred to which post?
Well, no, when I was there, I was there as TSPA or my lord, sorting assistant.
We don't know abbreviations, sir.
No, time scale sorting assistant.
Time scale?
Sorting assistant.
Yes.
No, time scale postal assistant. I'm sorry, man. Time scale postal assistant. I beg to be expressed. And my lord, sorting assistant.
From there you went as LDC.
LDC.
And in the time scale assistant, you were getting which scale?
No, the scale was, my lord, transfer, before transfer, the pay scale was 260 to 480.
60 to 480.
480.
And as LDC, what is the
LDC, my lord, the scale was 260 to 400.
and you say you were transferred with pay protection?
Pay protection.
Where is that order? Sir, this is not your consultation chamber. You
No,
please
no,
address us.
no, I'm
We
not
don't appreciate.
I'm not
don't
consulting.
appreciate- We don't appreciate this.
No,
Sorry.
I am not consulting, my lord.
Yes.
I'm not consulting. I'm just showing, my lord, the document. I'm just showing the document. I have referred here, my lord. Well, if my lord takes, my lord, the note I have stated, my lord, everything in the.
You tell us, leave aside the notes. Tell us, where is the order? That is the only thing that has to be seen. Can't wait all day for you.
No,
We are adjourning it.
No, your lordship, kindly bear with me for a moment.
Sorry. Yes.
No,
Adjourned as prayed by Learned Counsel for the respondent. Matter is adjourned for a week. Call the next case.
ডকুমেন্টটা কোথায় গেল? Oh. But I'm told that Jan. But only it would appear from the fixation of pay. No formal order is being issued. Chalo. But to who admit to action?
यूनियन ऑफ इंडिया नोटिस रिजेक्ट किया.
My lord, in this matter, appear for the respondent bank, my lord. My lord, my instruction is, my lord, today only I am appearing for the first time, my lord. My advocate has said, my lord, a copy of the application has not been served upon us. My lord. No, my lord, we have not been noticed also, my lord. Not been served with notice also, my lord. Because, my lord, I said, I tell your lordship, my lord, the advocate on record is, my lord, Sanderson Morgans. From day one, my lord. And maybe they are serving notice to the bank, my lord. So it is not coming to us, my lord. And now, my lord, day before. Because we have diligently appeared and contesting the matter on day one, my lord. No, I'm for the bank, my lord, only. I'm not for Union of India, my lord. Not required, my lord. Only bank, formal party, my lord. Only bank is required, my lord.
My lord, next Monday.
I think, my lord, Mr. Roma Ghosdosti is appearing, my lord. I know her, my lord. I will inform over the phone, my lord. He is
Monday.
I'm grateful, Lordship.
Item number 3. My lord, we are appearing on behalf of the appellant. My lord, this is a matter, my lord. This is a suit for, my lord, the declaration and rectification. Mainly, my lord, rectification. My lord, the appellant's husband and the father of the defendant, both are, my lord, the cousin brother. My lord, the defendant's father, 50% owner of this property. My lord, they already, my lord, the defendant's father already transferred the property. My lord, there is a mistake only, my lord, all are correct, my lord, the only plot number mistakes. My lord, the Chaudhary are correct. My lord, this Khotiyan number correct, Mauja correct, quantum of land correct. Only, my lord, mistake, my lord, the plot number. My lord, that we rectified. My lord, both the courts held that though, my lord, the partition suit between the partition deed, my lord, the father and the, my lord, the appellant's husband, my lord, they accepted that this land transferred in favor of the appellants. And quantum and Mauja all are correct. And, my lord, the defendant also accepted in, my lord, in the cross-examination that his father transferred my lord, the plot in favor of the appellant, plaintiff. Yes, my lord. But initially, my lord, matter was heard by your lordships, and your lordship directed the matter will appear as a 4 orders. As such, my lord, that present court, my lord, release the matter. And more the revenue court, the defendant raised the objection before the revenue authority. Well, kindly see the order of the revenue authority. Revenue authority corrected. Well, my name and recorded. Revenue
What was the prayer in the suit? Let us.
Well, suit only rectifications. Well, declaration and rectification of the deed in place of, well, the 1832, 1838 be recorded.
What was the prayer?
Well, in place of 1832, well, this is a deed which I purchased. Well, the recorded only plot number recorded 1832. Well, that be rectified in place of 1832, 1838.
For correction of the deed.
Correction of the deed, because, well, the vendors already died. Well, vendors is a
Was the only relief.
only relief.
Let us see where is the plaint.
ওটা তো পুরো ইয়েতে সুটের প্লেন কেস হ্যাঁ তো দেখো সুটের প্লেন সুটটা দেখো সুটের প্লেন সেটটা দাও ফাইল আছে
Let us see if that was the innocuous prayer, then nothing remains. Let us see.
yes my lord, this is এই তো না এটা তুমি একই ব্যাপার এটা ইনজাংশন আর সুটটা এটা প্লেন এই ইনজাংশন প্লেন দেখো তো প্লেন থাকবে কেন আরে প্লেনটা থাকবে দেখো তো ফাইল ফাইল প্লেনটা দেওয়া হয় প্লেন কি
No, you are seeking a declaratory relief also.
The declaration, rectification should be a true declaration.
You have gone through the relief sought.
Yeah, so yes, the rectification.
You have it right before us, declaring that the plaintiff are the absolute owners. You are seeking declaration of title
No,
And then
declare.
you are seeking a rectification.
No,
of the list.
rectification, my lord, through only, my lord, rectification, because, my lord, through declaration,
You may try to.
my lord, rectification through declaration.
Cannot simplify the prayer that you have sought before the.
No, kindly see the body of the plaint only relief.
We are looking at the prayer. The body may be anything. Therefore, we ask you what is the nature of relief. Relief is a declaration.
But declaration, my lord, through rectification.
You are not sure of your own title. Where is the question of rectification?
But there is no not the rectification, because, my lord, rectification should be
We are
through declaration.
guided by the prayer made by you before the trial court. You are not sure of your own right. You have sought a declaration. It is not a simple prayer for rectification of the deed. The two are two different things, completely different.
But kindly see the this next. But kindly see the plaint.
Kindly read the relief. Kindly read the prayer. A declaration that the plaintiffs are the absolute owners of the suit land, mentioned in Schedule B, measuring so and so details, and next prayer is rectifying the deed. Cannot be. If you have not purchased that land, how the deed can be rectified?
But I purchased the property.
You did not. It is not there in that the deed.
Yes, but I purchased. I annexed, my lord, the purchase deed.
It is not 1838. That is not the land you have purchased.
The partition deed. But the partition deed shows that, my lord, if 1838 is the defendant's father is not at all owner of the property.
We are not on that. If the deed shows a particular plot, then how it can be rectified unless when you are seeking a declaration?
But kindly,
right title then interest in that land.
But rectified, my lord.
What is the order of the two courts? Let us see. We have understood what you are trying.
এটা আমাদের অ্যাপিলের এটা
তো যাবে তার মধ্যেই তো দেওয়া আছে
জাজমেন্টটা এটা দাও রিমোট অ্যাপিল দাও তোমার টাইপ কপি আছে
ঠিক আছে Writing praise for declaration of title and permanent injunction expectation of property and rectification of penalties mentioned in seizure of property, measuring of property, or declaration of title and rectification of see either or. Right.
টাইপ কপি আছে
টাইপ কপি দেওয়া আছে সাহেবের কাছে ডিজিটাল কপি that is defendants for declaration of title, permanent injunction and rectification of deeds.
এটা কি অ্যাপিলেন্ট জাজমেন্টকে বলছে
অ্যাপিলেট জাজমেন্ট প্লেন কেসে বলছে সুটের জাজমেন্ট হতে rectification যেটা পড়ে আছে শুধুমাত্র রিজার্ভ করছি rectification of deed এর উপরে
counts of the promise, counts of yourself.
grounds the way to the grounds. Limitation, where is this? It is mainly within the declaration regarding the absence of progression. Whether they look at the honor of problem have also admitted in this process examination that the tips and the words in the portion of the vendor they view. It's not the owner of plot number of position. There is no limitation to prices. Declaration is fair recognition is formal in nature. It's the same spreading connection. In not accepting the recited portion of the registered deed of partition with the exhibit number 6, filed by the plaintiffs. Why there was such objection from the side of the defendants at the time of parting such document as exhibit, the different but the partition. The lecture himself the narrations are very excited of the partition evidential value.
But in the partition deed, learned judge, both the court findings that there is no evidential value in respect of the recital portion of the deed.
Yes.
Right, there is no.
This is reflection. Partition deed.
Partition deed, we whole share in respect of that land transfer as such, we have cannot be a party. The purchaser cannot be a party in the partition deed because the whole in the I purchase in respect of certain portion of the land. The Horipad or defendant's father, are in different plot. We purchase only one plot. One plot, purchase one plot, 165 decibel. His share, total share, transferred as such, I cannot be a party in the partition deed. And recital of the partition deed, his father accepted that this plot transferred to the brother's wife. Cousin brother accepted, evident. Kindly see the findings of the revenue authority. Revenue authority, the defendant himself challenged before the revenue authority regarding recording.
Of a finding of a revenue authority in declaration of title.
Title, only why I put a title?
Trying to take us to the
title because without declaring rectification cannot be made. As such, title. But we are in position.
You are trying to convince us by showing certain findings of a revenue authority. He has no business in title. We are seeing two orders passed by the trial court and the first appellate court. You say don't look at that, look at the revenue authority.
No, but first appellate court.
How the revenue authority is going to consider and decide the issue of title.
But title,
anything he wants.
title, I have no title, because without praying title, rectification cannot be made as such, my lord, title. My lord, title.
Made for a declaration that you are the rightful owner of the land, and then the second prayer is for rectification.
Because, my lord, without title, rectification cannot be made.
Rectification could have been done.
But it's simple, my lord, the suit for rectification cannot be made.
It is not a suit for rectification. It is declaration of title. It is belated. Everything is there. Both the courts have considered. Don't find.
Why, my lord, belated, my lord, kindly. 2000, when, my lord, they disposes, my lord, tried to dispose me, then, my lord, we file this.
Correct. You have not got a rectification done for decades. For decades together, you have not got
Because, my lord, in a partition suit, my lord, if, my lord, the vendor, my lord, this is one kind of declaration.
Claim to have acquired title by 3 sale deeds executed in early 70s. Partition took place in 78. The person whom you claim to be the vendor, he was alive for 15 years thereafter.
But because
no step taken.
But
Now everything after decades you are.
why, my lord, did not take steps? My lord, vendor declared in the partition deed that this plot I sold the property to the my lord, the appellant. Yes, my lord. So, yes, my lord. This is, my lord, I, as your lordship, my lord, I translate the copy, and, my lord, the Bengali deed I annex.
IA application. IA can application.
আরেকটা copy.
দুটোই আছে।
My lord, this is the my lord, the translate copy, my lord. Then, my lord, kindly see, my lord, there is annex, my lord. Annex in the Bengali, my lord, page
48.
Page 47. Page 47 in Bengali.
Page 47 in Bengali.
My lord, in 3. My lord, column number 3, page 48, 3.
Paragraph 3.
My lord, in my lord's, my lord, the type copy, my lord, the paragraph 3.
Yes.
This is, my lord, paragraph 3.
You have given us earlier.
Paragraph 3. Because cousin brother, my lord, that
He accepted the quantum of land and sell. Vendor accepted that. So, কপিটা কোথায় গেল? করতে পারবো সেটাই তো চাইছি। ঠিক আছে কি করি? না এটা নয়। Is with you. Plain. So, ঠিক আছে বাংলাটা তো আছে বাংলাটা তুই
No mention of 1838 anywhere.
That was India, my lord, 1.65. Kindly see. 1.65. আমার পৈতৃক অংশের মধ্যে
58 annas, sir. So that measure will remain same.
1.65.
1.65 will remain same because 8 annas both parties have.
Yes, my lord.
So therefore, where is the mention of 1838?
But 1838, my lord, this is the land. Or 1832.
8 annas is admitted. That is not, there is no dispute on
But 1832, my lord, the Horipoto is not at all owner.
of 1832, neither mention of
1832, my lord, the Horipoto is not at all owner of 1832.
does not resolve.
My lord, 1832, Horipoto not at all owner of that property.
that is ওনার শর্টটা মাপটা হচ্ছে 39 ডেসিমেল
And 1832, Horipoto is not at all owner of the property.
68, page number 68.
And kindly see the evidence of the defendant, his father. My lord, in a
Page
cross
65.
examination, page
Page
65, my lord, kindly see the application. Or page
65 of CAN application. Page 65. Declaration of title নয়, 1832 তে যে 39 ডেসিবেল সেটা পেজ 60A তে রয়েছে।
And my lord,
পেজ 60A
এই শিডিউলটা দেখো, শিডিউলটা,
which schedule?
আর partition schedule, হরিপদ schedule.
Partition detail.
My lord, kindly see the schedule of the Haripada. Haripada is the father of the defendant.
Schedule of partition.
Haripada is not the father of the defendant. Who is Shiva Prada?
Shiva Prasad is another brother. Satish, my lord, Dijen and Shiv, Haripada is the father of the defendant.
Of
Father of the defendant.
Defendant number 1.
Defendant, who is my lord raised objection?
Who raised
My lord,
objection?
defendant's father, Haripada. But this is the Haripado's share.
Statements in the
But Haripada is the original owner of the.
Yes, he had executed the 3 deeds.
He has executed.
According to you, he has executed the 3 deeds. They say no such deed was executed.
Now, but kindly see, my lord,
evidence.
Two people don't argue a case. This is not the way.
But 65, my lord, kindly application page 65.
It's
65, my lord, cross examination 4, on column 4. Plaintiff purchase his.
Who is he?
This is a defendant. Rabindranath Das, my lord, is the son of the Haripada. My lord, the plaintiff purchase his portion of share from Haripada in respect of the suit land by dint of 3 cell deed. My lord, rather he accepted, my lord, defendant accepted the plaintiff purchase his portion of share from Haripada in respect of the suit land by dint of 3 cell deed.
Yes, his share means his 50% share.
Yes, my lord, that is 50% share in respect of this land. But 309 Khotian, my lord, Khotian same. My lord, in a Khotian 1838, my lord, came from Khotian number 309. My lord, in a partition deed written as a Khotian.
जवाब लगभग ही নিতে হলে হচ্ছে My lord, general logic.
Yes, yes.
When you will give us?
My lord,
1 week.
1 week, my lord.
Wait, after 1 week.
Copy of that party.
Oh,
My lord, item number 4. Well, item number 4, my lord, Mr. Shobhan Kumar Nandi, he is doing another matter, code number 33. If you short password, my lord. Short. Good.
item number 5.
It's my application. 5 আপনি আছেন?
Bundle দিতে বলে যতক্ষণ যেতে আমারটা দিতে বলো।
এখানে ইমপ্লিমেন্ট অর্ডারটা কোথায়? Number way at page 13.
My lord, may I tell the facts?
They are at paste.
My lord. The petitioner's father died in 2006.
Viral binding.
My lord, there is delay. My lord, after 8 years, because this 2006 died, 2009, they took 3 years. Now, my lord, thereafter, this petitioner is the my lord should have filed within month, but that has not been done because he is the only son. His mother was ailing. My lord, none. My lord, in the way, my lord, the earlier advocate possibly this was not averted.
No application. Ten, 20, 21.
No MA, no condemnation, nothing.
These were not there in the tribunal. My lord, this was dealt with in a my lord, very casual manner. But insofar of the claim of the petitioner is concerned, my lord, on merit I can say, my lord, that he is deserved to be accommodated.
He is not interested, sir. If he was interested, he would not wait 9 years. You know the concept of compassionate appointment.
Lordship, that hurdle, this is my lord, quite unfortunate because of
The case of compassionate appointment, that's not a technicality, delay. It actually goes to the root of the matter because if you are not in need of immediate relief, then this is not for you.
But on the contrary, this is the duty of the authority. My lord, why should I come to court? Why should I approach this court for, my lord, having my right? They should
Not
have.
here to answer that. We are not here to answer that.
That's true. My lord. This is
Yes.
the case, my lord. I cannot improve.
Yeah,
But
yes,
my
sir,
lord,
it is-
this was dealt in a manner.
Hopeless case, sir. A person who wants a compassionate appointment will wait 8 years after rejection of his claim, after communication of rejection. And you are saying, why should I come to court?
My lord,
After rejection, you are not required to challenge. It's not a case where there is a belated application. This is a case of rejection in 2009.
2009, 2017 we filed. This has been decided. Your lordship kindly sees. This has been decided in 24. The tribunal also took 7 years. সব গুছিয়ে নাও।
Item number 6.
Six lordship in this matter, Mrs. Ramanandar appeal on behalf of the appellant, my lord. Service has not been complied, my lord. That's why I am praying for 2 weeks time, my lord.
Not today.
Item number 7.
My lord, item number 7, I am appealing on behalf of this petitioner. But my learned junior is out of station.
Yes, what do you want? What do you want, sir?
And he has, I have told that service is not complete.
Require service. Let us see the merits of the matter. If there is a merit, we will ask them to appeal.
My lord, this is a case of appointment to the post in fitter. The railway recruitment, my lord, issued notification for recruitment in several posts in different departments. The petitioner, including the post of fitter, CW. The petitioner, being the eligible candidate, made application to the authority concerned. Thereafter, he received the admit card in which he was informing that the written test scheduled to be held on such and such date. Accordingly, he appeared in the said examination, and the entrance time, the authority took signature as well as thumb impression and identity card. He sat in said examination and declared as successful candidate. Thereafter, he informed to appear for document verification. He appeared duly, and the documents was verified by the concerned authority, and ultimately he was selected, panel was prepared, it was published. Suddenly, after 2 years,
They have not matched your thumb impression.
thumb impression not taken at all. That is my only prayer.
Why we are asking you at the time of participation.
Yes.
They have taken your thumb impression.
Thumb impression. That
Serve a copy.
Lordship. Well, only my prayer, only whatever may be, my thumb impression may be according to the
Served an affidavit of service.
Thank you. Grateful, Lordship.
Yes. Taken up as an urgent matter by
Item number 8.
It is wrongly listed.
Item number 9.
My lord,
Yes.
I'm praying for not today on behalf of Mr. Patra Ghosh, learned advocate, praying for the petition. Huh?
Item number 10. Seven. 12.
I appeal for respondent number 5 of petition 4, 5 and 6. Not today.
13.
You are for
I am for the respondent.
all the next.
14. 15. 16.
16, my lord, I'm paying not today on behalf of Mr. Suborno Lakshman.
17. 19.
I'm for the petition also. In item number 19 also, I'm for the petition. 19.
Yes. Date of submission.
Only point which has to be decided by this court whether
What was the last date? As
Lordship,
per
the
letter
last
to
date,
is that one?
page number 65, Lordship. This is last date is given. This was on 3rd July. Last date of fees of payment was 3rd July 2018. And offline payment of the fees can be made up to 4th July 2018.
Not an issue of fee.
Lordship,
An issue of
issue of application, Lordship.
the closing date of application.
3rd July 2018, Lordship.
Closing date, July 2018.
18. Lordship, the admitted position is that this petitioner did not have the OBC certificate on that day. He made an application later.
We are saying, let us see what is the requirement as per the advertisement.
Yes, my lord, application requirements, Lordship, will find page 64, Lordship, clause B. SC, ST OBCs and disability certificate must be obtained within the closing date of receipt of application, and no claim in this regard will be entertained afterwards. This is also an admitted question.
The date of your OBC certificate?
My lord, my OBC certificate was obtained. It was obtained in 2019. I'll give page number to Malad.
So 6 months after this closing date.
Yes, my lord.
Then why should you be considered?
My lord, I will only place one judgment, and
Sure.
Lordship, this is Ram Kumar Gijoria.
Delhi High Court.
This is Supreme Court. Delhi High Court, Lordship, has considered Pushpa here. And later on, Lordship, the Honorable Supreme Court has referred this matter before its constitutional bench, which is pending. And considering that position, Lordship, Lordship, here in citation is 2016 4 SCC 754.
If I remember correctly.
Pushpa was by Delhi High Court. The Pushpa, I got Pushpa.
That has been considered in
Gijoria's case. And later on, this Honorable Supreme Court very recently referred the matter by by distinguishing Pushpa and factually distinguishing between Pushpa and Gijoria. Lordship, Gijoria, Lordship, kindly come to the relevant portion, paragraph 14 onwards. May I read? The division bench of the High Court erred in not considering the decision rendered in Pushpa. In that case, the learned single judge of the High Court had rightly held that the petitioners therein were entitled to submit the OBC certificate before the provisional selection list was published to claim the benefit of the reservation of OBC category. The learned single judge correctly examined the entire situation not in a pedantic manner, but in the backdrop of the object of reservations made to the reserved categories, and keeping in view the law laid down by the Constitution bench of this court in Indra Swani versus Union of India, as well as in Valsama Paul versus Cochin University. The learned single judge in Pushpa also considered another judgment of Delhi High Court in Tejpal Singh, wherein the Delhi High Court had already taken the view that the candidature of those candidates who belong to SC and ST categories could not be rejected simply on account of the late submission of caste certificate. The relevant paragraph from the judgment of this court in Indra Swani has been extracted in Pushpa along with the speech delivered by Dr. Ambedkar in the Constituent Assembly and reads as thus. 9. 251 paragraph referring to the concept of equality of opportunity in public employment as embodied in Article 10 of the draft Constitution, which finally emerged as Article 16 of the Constitution, and the conflicting claims of various communities for representation in public administration. Dr. Ambedkar emphatically declared that reservation should be confined to a minority of seats, lest the very concept of equality should be destroyed. In view of its great importance, the full text of his speech delivered in the Constituent Assembly on the point is appended to this judgment, but I shall now read a few passages from it. Dr. Ambedkar stated, quote, firstly, that there shall be equality of opportunity. Secondly, that there shall be reservations in favor of certain communities which have not so far had a proper look in, so to say, into the administration. Supposing, for instance, we were to concede in full the demand of those communities who have not been so far employed in public services to the fullest extent, what would really happen is we shall be completely destroying the first proposition upon which we are all agreed, namely that there shall be an equality of opportunity. Therefore, the seats to be reserved, if the reservation is to be consistent with subclause 1 of Article 10, must be confined to a minority of seats. It is then only the first principle could find its place in the Constitution and effective in operation. We have to safeguard two things, namely the principle of equality of opportunity and at the same time satisfy the demand of the communities which have not had so far representation of the state. These words embody the raison d'etre of reservation and its limitations. Reservation is one of the measures adopted by the Constitution to remedy the continuing evil effects of prior inequalities stemming from discriminatory practices against various classes of people, which have resulted in their social, educational, and economic backwardness. Reservation is meant to be addressed to represent social, educational, and economic backwardness caused by purposeful societal discrimination. To attack the continuing ill effect and preparation of such injustice, the Constitution permits, empowers the state to adopt corrective devices even when they have discriminatory and exclusionary effect. Any such measure, insofar as one group is preferred to the exclusion of another, must necessarily be narrowly tailored to the achievement of the fundamental constitutional goal. In Pushpa, relevant paragraph from Tejpal Singh have also been extracted, which reads thus. Paragraph 15 is quoted. The matter can be looked into from another angle also. As per the advertisement dated 11 June 1999, issued by the board, vacancies are reserved for various categories, including SC category. Thus, in order to be considered for the post reserved for SC category, the requirement is that a person should belong to SC category. If a person is SC, he is so by birth and not by acquisition of the category because of any other event happening at a later stage. A certificate issued by the competent authority to this effect is only an affirmation to fact which is already in existence. The purpose of such certificate is to enable the authorities to believe in the assertion of the candidate that he belongs to SC category and act thereupon by giving the benefit to such candidate for his belonging to SC category. It is not that petitioners did not belong to SC category prior to 30th June 1998 or that acquired the status of being SC only on the date of issuance of the certificate. In view of this proposition, necessitating upon the certificate dated prior to 30th June 1998 would be clearly arbitrary and it has no rational objective sought to be achieved. While taking a particular view in such matters, one has to keep in mind the objectives behind the post of SC and ST categories as per constitutional mandate prescribed in Article 15.4 and 16.4, which are enabling provisions authorizing the government to make special provisions for the person of SC and ST categories. Article 14.4 and 16.4 therefore intend to remove social economic inequality to make equal opportunities available in reality. Social and economic justice is a right enshrined for protection of society. The right in social and economic justice envisaged in the preamble and elongated in the fundamental rights and directive principles of the Constitution. In particular, Article 14, 15, 16, 21, 38, 39, and 46 are to make the equality of the life of the poor, disadvantaged, and disabled citizen for the society meaningful. Then it quoted Tejpal Singh. Now, further in Pushpa, the relevant portion from the judgment of Valsama Pal Singh has also been extracted, which reads as under. Pushpa case was quoted, paragraph 21, the Constitution, through its preamble, fundamental rights and directive principles, created a secular state based on the principle of equality and non-discrimination, striking a balance between the rights of the individuals and duty and commitment of the state to establish an egalitarian social order. In our considered view, the decision rendered in Pushpa is in conformity with the position of law laid down by the court, which have been referred to supra. The division bench of High Court erred in reversing the judgment, an order passed by the learned single judge without noticing the binding precedent on the question laid down by the Constitution bench of this court in Indraswamy and Valsama Pal, wherein this court, after interpretation of Article 14, 15, 16, and 39A of the Directive Principles of the State Policy, held that the object of providing reservation to the SC and STs and educationally and socially backward classes of the society to the remove inequality in the public employment as candidates belonging to these categories are unable to compete with the candidates belonging to the general category. As a result of facing centuries of oppression and deprivation of opportunity, the constitutional concept of reservation envisaged in the preamble of the Constitution as well as Article 14, 15, 16, 39A of the directive principles of the state policy is to achieve the concept of giving equal opportunity to all sections of the society. The revision bench thus erred in reversing the judgment and order passed by the learned single judge. Hence, the impugned judgment and order by the division bench in latest patent appeal number such and such is not only erroneous but also suffers from error of law, as it has failed to follow the binding precedent of the judgments of this court in Indraswamy and Valsama Pal. Therefore, the impugned judgment and order passed by the division bench of the High Court liable to be set aside, accordingly set aside. My lord, I got one judgment, Lordship, I got. This is in 2024. Lordship, the Supreme Court, with 3 judges bench, considered this issue, and in 2024, 2 SCC 714 referred it. Ito to. No, reference to it. Lordship, kindly come to paragraph 4. Considered Gijoria. Maybe 2016. No, it is over. What is it? 2022. Yes, my lord, that is the position of law. Now, Lordship, I got one judgment that if the matter is pending before the Supreme Court, before a constitutional bench, then what should be the binding effect of the earlier judgment? Lordship. Yes, Lordship, I
Here is question is, if there is a notification issued by the Public Service Commission that application has to be submitted with such and such date.
Have you seen the Gijroya's case?
Yes.
You have seen Gijroya's case.
No, what I just I read, but give me some time so that I can.
Therefore, we are asking you. We understand what you are saying, but Gijroya's case relying on Pushpa judgment, has said that if the application for issuance of the certificate was issued
Yeah.
and the authority has delayed in issuing the certificate, then whether the candidate can be non-suited in the.
Yes, that is the point.
So therefore, just have a look. What is
Yes.
the legal position? We will hear this matter.
Yes.
Yes, yours.
Well, I have to only cite one more judgment, that is the Karan Singh Yadav, that considering the situation that when the matter is pending before the
Larger bench, but there is a conflicting view. When larger bench issue is pending, let it be adjourned till the
No,
matter
that is
decided.
the
But or in other judgment, but our High Court and
preceding
no, but then the law laid down.
It is the binding effect. The earlier judgment will operational, subject to correction.
That's why
Lordship.
that in a Madras High Court,
Rajneesh Kumar Rai, 2023, 14 SCC 784. The presidential binding status when matter pending reference or to pending before the larger bench. Decision referred to larger bench retreated continues to hold the field until decision of the larger bench. Lordship, kindly come to this is judgment passed by the Honorable Justice Bose. 2023 14 SCC 782. Lordship, kindly come to paragraph 42. Needless to say, the power of judicial review. 42. Lordship, this is Rajneesh Kumar Rai. Lordship, this is para 3. Sorry, Lordship, it's a internal para 40. I'm very sorry. Para 3. The High Court relied on the following passage from Alapon Bandyopadhyay in dismissing the writ petition, holding that it lacked territorial jurisdiction to entertain the petition. It has been interiorly held that Alapon Bandyopadhyay's case, the undisputed and indisputable position in this case is that WPCT number 78 of 2021 was filed to challenge the order dated 22nd October 2021 in Union of India versus Alapon Bandyopadhyay of the Central Administrative Tribunal Principal Bench at New Delhi by chairman of the tribunal in exercise of the power.
That is why we asked you anything subsequent to this. That is why we
That is the latest position.
So we are asking him, let him have a look.
My lord.
Because even the dissenting judgment is of 2020.
Yeah.
It may be reported in 24, but it is of 2020.
The subsequent development, I did not find, Lordship.
Second judgment that you have given us.
Yes, my lord.
Where Ramkumar Gijroya's matter was referred to larger bench, it is of
2020. After that, Lordship, I did not find anything. So for this.
We are saying let him see.
Yes, my lord.
The learned counsel for the.
Number 20.
But 20 we appear for the applicants. But 20 is a case where the petitioner had claimed for recognizing his date of appointment for seniority. But what has happened is, but into the year 1992,
Seniority as
been identified from the year 1995. But the scenario
he wants his seniority to be determined from the date of
joining, that is the date of appointment, that is 1992. But in various correspondences, they have acknowledged that my date of appointment is 1992.
What is the date?
I joined in service in the year 1992. Yes, my lord. I am just coming, my lord. 14/9/1992. This is the date of joining.
Joining as
my lord, assistant librarian, my lord.
which organization?
National Library, under compulsion appointment. Thereafter, I was regularized from 28/9/1995.
So you want antedating by 3 years?
Yes. Now, what has happened, my lord?
Relying upon which provision? Where is the scheme for compassionate appointment? What does?
My lord, if your lordship kindly takes up page 80, my lord.
Let us hear him.
Page 80, my lord. Is the scheme for compassionate appointment. Now, page 81, point 15, seniority. The inter se seniority of a persons appointed on compassionate appointment may be fixed with reference to the date of appointment. My date of appointment is 14/9/1992. So I claimed, I prayed before the authorities to recognize this date for granting seniority.
Yes, and what date? From where are you saying?
I am for the respondent.
Yes. Where is the order appointing you?
Yes, madam. But kindly takes up page 72, madam. 74 would be the precise one. 74. 18/9/1982. This is my appointment letter. But may I read, my lord? See here, my lord, they have accepted her seniority will be fixed as per rules. My lord, yes, sir.
Which is the rule? Which is the underlying rule?
But the scheme for compassionate amendment, if your lordship kindly takes up page 81. 81.
One is the scheme for
Yes. Number here these
for the department, or it is the general rule?
It's the general rule, my lord.
Scheme.
Yes, my lord. The general scheme says that the seniority would be decided from the date of appointment. That is the scheme. Point 15, seniority.
That is not relevant. The appointment order says seniority will be fixed as per rules, not as per the scheme of compassionate appointment.
Yes.
What is the rule for a recruitment to this library?
No, I'll say, but in 1992, I was appointed on compassionate amendment. I was granted that.
How many times you will see?
But
that? You have
I'll just
already
satisfy
said that.
Yes, my lord.
You have already
Later
said
on,
that.
later on, my lord, in 1995, I was regularized after having the diploma, and I was given the post of assistant librarian. Granted promotion. My lord, if your lordship and holding the same post from the day one.
This was the rule, sir.
Yes, my lord. But today, my lord, I do not have the particular rules of National Library. But may I just say one thing, my lord?
With the rules, we don't want to waste time. Yes, take down. Learned Council for the
For appointment rules, sir.
Lordship, may I be permitted to mention item number 106?
Not at this time, yes.
My lord, your lordship has directed me to
Yes,
produce
that's
it.
why we are calling upon you, yes. Filing compliance report, file it.
My lord, we have to pay
You
the
see-
pension, otherwise our salary will be attached, my lord.
After the failing which, if you don't file compliance report, they will, why should they not attach the salary?
My
You
lord,
file a report. File a report. Where is the apprehension right now that any salary will be attached?
My lord, it is written there itself, my lord.
Please read it.
My lord, it says the respondents are directed to comply with the order dated 21/12/2021, that is to pay the pension.
Please read it. Yes.
Passed by this tribunal in OA number so and so and file compliance report within 6 weeks.
Why
Failing,
should you not? That's what we are asking you.
my lord, I will
Why
try.
should you not
I will
file a
try to
complaint?
satisfy your lordship that this order cannot be complied with, my lord.
You have tried to get the order modified also.
My lord, that is only with regard to notes of argument, my lord. I have not modified the entire order, my lord. Only it was my notes of argument was not considered. That for
With the
that I had
orders, sir.
filed.
This is not a forum for staying the orders of the tribunal just like that.
My lord, I'm not praying before
Why
your lordship
should you
to.
not comply with the order?
My lord, your lordship will give me 5 minutes, my lord, to satisfy your lordship that this order cannot be complied, my lord.
You file a report, we'll see what happens after that. Let's see what happens. You may be able to convince the tribunal. Not a case of urgency. And the order is of 17/2.
No, my lord, this is of 10/12/2024.
So 6 weeks has lapsed.
My lord, 6 weeks have
You
left.
have waited now. Sorry.
My lord, I have filed the application within that 6 weeks, my lord.
That order is now more than 6 weeks old. Why do you keep sitting on the matter for so long?
My
First,
lord,
you don't comply with the order and then you wait for the last moment so that you can show urgency.
no, my lord.
Let us say somehow. We are not inclined to interfere in matters like that just at the drop of a hat. This is a full-fledged proceeding before the tribunal. Have you challenged the order passed by the tribunal?
My lord, I am challenging here itself, my lord. In WPCT, I am challenging the order of the OA application because, my lord, the OA application I could not have challenged because I had filed one MA application for modification of the order of the original application. Now that has been disposed on 10/12/2024, my lord.
That's not yesterday, sir. 10/12 is not just yesterday. That's why we are asking you.
My lord, 1.5 months back, my lord.
Yes,
It was this one.
1.5
Thereafter,
months back.
thereafter, I have challenged, my lord. It is pending before your lordship, my lord.
When did you file it?
On 18th of January 2025, my lord. It is affirmed on 18th of January 2025, my lord. I'm grateful, my lord. Item 146. I'm grateful, my lord.
Lordship, 106 is a matter where the person is not getting his pension for the last.
Not the mentioning time, sir.
I understand, sir. Lordship.
That's why we said not this
I
time.
come from Delhi today. The flight was delayed a little bit, Your Lordship.
Number 21.
Order. I'm for the original applicant, respondent number 1.
Item number 22.
My lord, my learned senior who is representing the respondent in this matter could not come today due to health issues. I'm praying for not today, my lord.
My lord, also kindly this will happen next Friday. Because I will not be here, my lord. I'm going to go. My lord,
Number 23.
No, I'm pretty sure, Lord. Just no, court will not touch my blood. Sorry, I'm sorry. Oh, yes, yes, Lord. 1 week. Diplomatized, Lord. Yes, sir. Item 22. I have for the petition. Gratefully, Your Lordship.
Item number 24.
This is my application. I'm filing affidavits. After it. Filing affidavits.
What is your submission? The tribunal has failed
My lord,
to consider the distinction between class A and C.
My lord, my submission is this, my lord, my ground is this. Applicants were appointed at group class C, gatekeeper. And first OA, my lord, was disposed of with direction to consider the representation of the applicant.
Why we are making a query, sir? Since we have gone through the order, we are asking you, is there a distinction between the duty hours for a class
Yes,
A and
yes,
class
yes,
B?
yes.
So that the
Class-
tribunal has omitted to consider.
That has not been considered. And my lord, kindly see
What is
page.
the distinction? Show us.
My lord, that I have restriction, my lord, I have said, my lord, kindly see page 100.
What is that page 100?
Kindly see page 100. Pursuant to direction of the learned tribunal, my lord, this order has been passed.
We are asking you to show what is the distinction. You are showing us the order.
That I have stated, my lord, paragraph B, page 6. There are 5 classes of level crossing.
So in class A, there is 8 hours duty, and class C, there is 12.
There are different, because this is non-BG gate, and that is why this was not applicable over time. Class C, my lord, is stated, my lord, A, B, special class, page 7.
Yes.
Special class for roads, TBU greater 50,000, a TBU between so and so,
What is
or
TBU?
line.
What is TBU?
That is just one. And B class for.
What is TBU, sir? What is TBU?
That I have not here.
Train vehicle unit.
You are representing them and you don't know what is TBU.
Train
Vehicle unit.
train vehicle units. And class B for 30,000 train vehicles units. And B has also been divided B1, B2, then class C for roads. All other level crossing. And that is non-BG. That is non-BG road crossing. That I have explained in the speaking order passed as per direction of the learned tribunal. If my lord go through that order, my lord, it will reflect that the order.
Where is the rule? Show us the rule.
Rules.
Where is rule 8.2? Paragraph 8.2. Which?
Just a minute.
Eighty. 85.
Page 85, my junior said. Page 85. Fixation of work, hours of work. And next page, my lord, page 86, mention gate main C caretakers. Page 86. Third paragraph. Clause 4.
Plus 24, 72 hours in a week. Which we have stated in paragraph 8, page 20. Essentially. Return commitment. Page 28. Yeah. Given such and such case is given leverage 20.
How many working days in a week?
That is actually, madam, that has not been mentioned here, madam. But 7 days.
डेज के हिसाब से नहीं बोला गया, आवर्स के हिसाब से बोला गया। वहाँ कुछ
48 hours a week, my lord, plus 24 hours additional per week.
They are asking you how many working days a week.
Working day is not mentioned, but as per hours mentioned, my lord, per hours per day. That day, 48 hours in a week. See,
Hours in a week means what? In a week to be calculated per 7
in
days,
a week.
6 days, 5 days, how many days?
48, yeah, my lord, page 86.
Sir, we have seen 86, that's why we are asking you.
Yes,
The
ma'am.
week is must be defined. A working week is comprising of 5 days, 6 days, 7 days. Otherwise, how can you break up?
My lord,
Sir, basic
here, my lord, as per rules, my lord, asking, my lord, that has been mentioned 48 hours in a week and plus 24 additional
What is
24.
mentioned, we are reading. What is mentioned, we are reading. We are asking you,
Yes,
what
sir.
is the number of working days in a week for this class of employee?
My lord, here that I do not find, my lord, regarding the, my lord, number of days. As per rules mentioned, my lord, 48 hours in a week. Additional group C gateman.
You need not read what we have already read. We are
Yes,
asking,
my lord.
we are making a query. We want, you have
That
to
has-
ascertain.
My lord, that has
How
not.
can you avoid, how can
that-
you ask them to work 12 hours in a day when you don't know the number of working hours, working days in a week?
That's right, my lord. That I have to take instruction, my lord.
For that, you need to take instruction.
That I can do.
There's a basic thing here, and for that, you need to take instruction.
That I will take instruction.
Ask them, not today. Come back tomorrow.
Yeah. Can it be, my lord, on Tuesday, my lord? Tuesday, my lord, instead of Monday, my lord, make it Tuesday. as your lordship please.
Instruction you require for this.
No, no,
So the entire rule you will find yourself.
here we do not find in the rule, that's why I am asking.
Must be in the rule. If I read it all, I will find it, I'm sure.
Then I have
Not
to
be.
take it, that's why.
Yes.
As your lordship.
25.
My lord, in 25, my lord, I am for the petition. দুটো লাগে সার্ভিস তো একটাই My lord, petitioner is the employee of Eastern Railway.
Just give us a minute. Let us see the order.
Take grade 1 under this gift.
Interim order.
Yes, my lord. My lord, the problem is, my lord, after 18th of June 2024, my lord, the Honorable Tribunal was pleased to direct the respondent to file their reply. But till date, they have not given any reply. And they have taken adjournment each and every day. And for that reason, my lord, petitioner's stay application has till date, my lord, that application has not yet been heard. So now I am humbly pray before your honor, before your lordship, kindly direct the tribunal to hear out the petitioner's stay application without the reply.
Stay prayer.
Huh?
Stay prayer.
Stay prayer.
This is an order of 18/6/24.
Yes.
On that day, you have moved for a stay.
Yes.
They have been directed to file their
Reply.
reply.
But thereafter, my lord, each and every day,
Each and every day. What happened on 13/8/24?
they have not given the stay application, reply, and then the petitioner was adjourned.
Last order server copy is there also.
They will consider when it is filed.
Last order server copy যদি চাই দিবেন
Your lordship kindly see the last order, the server copy of the last order, my lord.
Something which is not on record, sir.
Yes.
Interim order is to be passed in this case.
My lord, petitioner got 97.33,
What is the interim order that can be passed
but not to give any appointment.
against the vacancy?
Yes.
Now what at this belated stage, what can be
No,
done?
my lord, at the first stage, my lord,
How it is, much water has flown. This is more than a year old now.
That is their difficulty. They did not file reply.
my lord, they did not file their application for that reason, my lord. Now I am suffered.
That we have understood.
Yes.
But when was the result declared?
My lord, result declared immediately thereafter, my lord, I moved.
When was the result declared?
কবে করেছি? 9th of April 2024.
Correct. So
Yes.
now where is the question of
But
keeping?
immediately thereafter, I filed this application.
Now there is no question of any vacancy being kept vacant more than a year later.
But till that vacancy has not been filled
We
up.
don't know. We don't know. We don't know.
Let them to file reply.
We don't know.
But then your lordship can direct my learned men to file their affidavit.
Do it there. Why should we take it up when the matter is already being
But
considered?
your lordship kindly to fix a date, stipulated time. Within that period, my lord, they should file their affidavit.
Do it, sir. They will do it.
Yes, my lord, your lordship kindly give this.
You have said in the affidavit in your writ petition that the vacancy is still vacant. Have you said so?
বলেছি ওটা vacancy টা vacancy টা এখন vacant নেই।
Then nothing. Then they will file their affidavit. Yes, hard learned counsel.
Vacancy আছে, যেই vacancy আছে।
Lordship kindly give directions upon my learned men to file their reply. My hello.
Due to learned counsel for the respondent submits that before just take down learned counsel for the
করে দিয়ে যাবো একটা।
Item number 26.
26, Lordship, I appear for the petitioner in this matter. I've served, my lord.
I appear on here, ignorant of India, led by Mr. Supriyo Thaman.
The date of charge memo?
Charge memo, Lordship. 21st of August 2023. My lord.
My report has been submitted.
May I just submit, my lord? The short point involved here is the inquiring officer himself produces a witness, examines him.
No presenting officer.
There was no presenting officer, inquiring officer, Lordship. Himself examines, himself cross-examines his own witness.
Was any presenting officer appointed by the disciplinary authority?
Lordship kindly sees only the inquiry officer. Kindly comes to page number 77 of the application. Now, person himself produces a witness, himself cross-examines.
We are saying only if presenting officer was not appointed, then only the disciplinary authority or inquiry officer would be taking it upon himself to adduce the witness and examine.
Lordship, in my humble submission, right of cross-examination lies with the railway servant. As per the rules as well, the railway servant gets to cross-examine the witness. I was.
Before that, there is
Lordship.
a stage where the witnesses are examined.
Lordship.
They are examined by the presenting officer. And for that purpose, a presenting officer is appointed.
Lordship, everywhere it has been signed by inquiry officer.
Therefore, we are asking whether presenting officer was appointed at all or not.
Lordship.
That itself is an infirmity which may
Lordship.
vitiate the entire proceedings.
Lordship.
Therefore, we are asking.
May I seek just instruction, Lordship?
Yes, so come to your para 3 of the cat's order.
Yes, Lordship. Yes, Lordship. Yes.
There was no presenting officer.
No presenting officer.
At this stage. No final order passed by the disciplinary authority.
There is, Lordship. I have annexed it. This is at page 105, my lord.
What is the order?
Based on the inquiry report, I have been removed from service. Kindly comes to page
The cat's order
105.
records that the
It has recorded that they'll proceed expeditiously.
there is no final order of the disciplinary authority.
Yes, Lordship, there is 105. Kindly comes to page 105. Ordering portion is at 106.
This was before the tribunal.
This was before this was passed, I had approached because of the violations of the principles of natural justice and the extreme perversity.
Of the order by the tribunal, this order was already there. No, it was not. This is of tribunal's order is of 15/5 and this is of 3/6.
3/6, Lordship. 2000. No, this was not before the tribunal, Lordship.
Now you have to challenge that.
But Lordship kindly sees the procedure that they have followed. It is completely vitiated. I have, may I be candid, my lord, I have filed an appeal, Lordship, but however, I have also, an appeal is pending. I have annexed all the documents. I have filed an application request beseeching that this point may be taken up as a preliminary issue. If the appellate authority decides on that first, even that would be suffice. But then Lordship kindly sees the perversity in the entire proceeding. Appeal is pending, Lordship. I have preferred an application. However, Lordship, I beseech my lords to interfere at this stage because of the perversity.
Have the departmental remedy. You did not challenge the order of the disciplinary authority before the tribunal. How can we look into it?
Lordship, if the procedure itself is perverse, Lordship, that should attract the interference of this honorable court. That is my humble submission. He himself cross-examines the witness.
That we have understood. So we said that may be enough to vitiate the entire proceedings.
The entire proceeding is vitiated, Lordship, then the final order itself also suffers from that same infirmity.
Objection regarding
I have raised that objection.
before the inquiry order.
Before the inquiry. My lord, kindly grants me a moment. My lord, kindly comes to page 64. This was my complaint, my lord. And also, lordship, at page 91.
There is no such objection.
Kindly comes to page 91 as well, my lord.
The appellate authority pass an order, then you come, not the time. If you have raised this issue before the appellate authority, let it consider. Your appeal is pending since when?
My lord, my appeal has been filed.
Appellate authority, is he a party to these proceedings?
My lord. Principal Chief Signal and Telecom Engineer is the appellate authority. Then, lordship, may I just beseech one humble prayer, my lord. Let the appellate authority decide my application first.
That's what we are saying. So where is he a party?
Lordship. No, my lord, the Principal Chief Signal and Telecom Engineer is not a party.
Did you have the details? When did you file the appeal? Is there
Yes,
anything in
lordship.
the pleading here regarding file of appeal?
Lordship. Oh, we filed which appeal?
Have you been stated in the writ petition that?
Yes, lordship, I've stated in the writ petition, my lord. My lord, page 107, I have made a representation for the punishment notice. My application that I have made, lordship, is at page 127.
Is 127?
Yes. I filed the appeal on 18th of June 2024.
The Direct someone who's not.
And Lordship will kindly record that I was not allowed to cross-examine the witness. Just one recording may be given, that I was not allowed to cross-examine the witness.
That she was not allowed to cross.
Your Lordship, in item number 27, Senior Advocate Mr. Bharat Bhushan is appearing in court number 37. He is next week. I'm for I'm for the petitioner, Your Lordship. Not today. Your Lordship.
Number 28.
Your Lordship, in this matter, I'm appearing for the petitioner, Your Lordship. Mr. Shankarnath Mukherjee is for the petitioner, Your Lordship.
I'm for the writ petitioner respondent.
Your Lordship, I'm praying for not today, Your Lordship.
What item number 28?
28 and to 30, Your Lordship.
Same.
Same
All the
matter.
parties are all.
Huh?
Same council in all.
Same
council.
council.
29.
My Lord, I am appearing in person in this matter.
31.
29 has not been called.
20 থেকে 30 হয়ে গেছে।
না 29 তো আমি দাঁড়াইনি, parties are available. 28 and 30.
28 and 30. 29.
My Lord, affidavit of service. My Lord, may I take your Lordship to the impugned order at page number 90 of my application. My Lord, in this writ petition, my Lords, I have.
At the beginning, my Lord, I would have prayed some time in this matter because of the fact I think that there are some, my Lord, the unreported judgments in the matter with regard to the petitioner's claim regarding this, that he is a patentee. My Lord,
That he is?
that he is a patentee.
Let us read. We'll just give us a minute.
If need, Lordship, kindly
Let
give
us
some.
read the order with the. What was the material before the Honorable Single Judge? Show us.
My Lords.
In support of your patent.
My Lords. My Lord, may I take your Lordship to page number 70. Page number 69, my Lord. Sorry. Page number 69 of my application. My Lord, may I read the order? Sir.
Yes.
My lords, my lord, in this writ petition, my lord, there is a specific observation at page number 70 in the middle portion. In the event state has the court has come to prima facie finding on 17 June 2015 that the plaintiffs who are the writ petitioner in this proceeding are the holders of patent in respect of technology applied for battery operated rickshaws. And the parties to the suit were restrained from infringing the plaintiff's patent in relation to eco-friendly vehicles. The state is aware of the said order. In the event state has granted any such license to the defendants in CH number such and such, those registrations shall be immediately cancelled. My lord, this was the observation of the writ court, coordinate bench, based on the suit filed before the original side of this honorable court. My lord, I am the patent holder or not was not the issue before this writ court, my lord. I am making this submission at bar because the issue is very much different in this writ proceeding. My lord, I have challenged that whether, being a citizen of India, I have challenged that whether unregistered plying of e-rickshaws are permissible under section 39 of the Motor Vehicle Act. Secondly, I have challenged whether Howrah Municipal Corporation can enroll, can grant registration as per section 39 of the Motor Vehicle Act. That was the crux of the issue. My lord, with regard to this, I am patent holder or not, that was not the issue before the learned single bench. That will be decided in the civil suit, which is pending before the other jurisdiction of this High Court. My lord, may I take your lordship to another one judgment, page number 61, my lords, kindly. My lord, the Honorable Division Bench, the Honorable Chief Justice-led Division Bench has been pleased. I was the intervener in that proceeding, was pleased to direct the state that unregistered e-rickshaw should stop by 31st August 2019. But still it was not stopped. I was the intervener therein. And learned single bench struck off the division bench order, my lords. My lord, may I take your lordships, my lord? Page number 61, my lords. My lord, this was rendered by Tripura High Court. I have filed a writ petition with the similar cause in the Tripura High Court, and Tripura High Court has banned the illegal business and operation of unregistered e-rickshaw with the observation that this writ has nothing to do with the patent suit and right of the petitioner. At page number, my lords, 11, page 67, my lord, para 11, having of...
You want to cite?
My lord, one more judgment, my lords, kindly.
Yes, we have seen, just, yes. No issue of patent in this matter. There's no issue of which judgments you want to show.
My lord,
When do you want to show it? Tell us.
may I tell?
When do you want to cite the judgments? You said you
My lord,
wanted
there
to.
is a, my lord, the contention all along.
Said you want to cite some unreported judgments. When do you want to cite? We'll fix a day for hearing.
My lord, kindly, my lord,
Please exchange the judgment so we can hear it on
yes,
one day.
I'm coming. Lordship, kindly, my lord, so far the writ petition is concerned. If your lordship kindly have a look, my lord, the prayer in the writ petition.
That's after seeing that only we are asking you. Only after seeing the prayer at page 56 we are asking you.
At page 56.
Yes, then
Now,
only we are asking.
now, my lord, kindly have a look at the, my lord, the representation that he sought for
Sir,
the
we are
purpose of
you said
consideration.
there are judgments which you want to cite.
My lord.
Therefore, we are asking you, when do you want to
My lord,
cite
may I-
it?
yes, my lord, say kindly, my lord, keep it, my lord, any day, lordship.
You tell us, you have
My
to
lord,
show the judgments.
because, my lord, may I tell one thing? First of all, my lord, if this is not an issue with regard to his patent right, now he says that this is not an issue.
No, now he doesn't say. You show from the prayer. Where is the issue regarding patent?
My lord, the prayer, lordship, that
Which prayer is concerning his patent rights?
my lord, the prayer B is that with regard to consideration of his representation.
Yes.
Of dated 13th June 2024.
Yes.
Now, my lord, that representation of 13th June 2024
Yes.
is at page 81. The
in person
foundation
আছে,
of
in
his
person আছে,
whole,
back
my lord, the claim based on his that, my lord, alleged patent right. At page 81, his representation.
So therefore, you will not consider. Is it the state stand that they will not consider the representation?
No, I'm not on that.
We are on that, sir.
I'll
We
get
are
to
not saying you allow. We are not saying you disallow.
My
Why should you not consider?
lord, this representation, lordship, kindly have a look.
Yes.
Kindly have a look. I, Konix China, the patent holder of battery-operated eco-friendly e-rickshaw, then such and such order dated, High Court, a photography of said order is attached. It appears some radio cab apps, namely Uber, Rapido, are facilitating illegal business and operation of illegal e-rickshaw. As per the order of the Honorable High Court, in above plying of unregistered e-rickshaw hazardous to
This has
public
nothing to do
safety.
with his patent. This has nothing to do with his patent. You want to show some judgments? We are fixing it, or
Now,
if you want to
so
proceed
far,
today, we'll
so far those judgments are concerned,
Yes.
my lord, 2 or 3 judgments are rightly with me with regard to his patent right. Now, my lord,
Why are you entering into his patent rights?
No, because-
He is at the very outset, he says he is not making an issue of his patent right.
now he says this is.
No, in the prayer also he does not say it. In the representation also, he claims to be having a patent, but the whatever he is saying is not in relation to any patent rights.
May I tell? Now, before the appeal court, he is saying all these things. But in his writ petition, there are, my lord, the most of the paragraphs, there are averments that his, my lord, the right accrues because of his patent right. He is a patentee. And because of that right under the Patent Act, he is a patentee. So he filed this writ petition, and my lord, the direction upon the state respondent to look into his grievances that unauthorized auto rickshaws or such and such as applied.
He is saying we will record that he is pressing the relief without any claim in respect of his patent rights.
Then, my lord, then the question is, I leave it to your lordship, but the question is then, my lord, his locus standi with regard to the filing of the writ petition.
Therefore, we are asking you, which are the judgments that you are relying on?
The judgment that is, well, with regard to his patent right, there are so many judgments at his instance, my lord, for last several years,
Then
he is
this nature of relief, if it has nothing to do with your patent rights, as you are saying, we appreciate that. Then it has to be a PIL. Why you are filing a writ?
My lord, may I take your lordship? At first, I have filed a writ petition before Her Ladyship, Honorable Justice Rai Chattopadhyay Ladyship. Her Ladyship is of the view that the prayer is of the PIL nature. So I went to the PIL court. The Chief Justice said that since you are having the patent right, so you cannot file a PIL. My lord, my lord, my lord, my lord, that was informed to the learned single bench because matter. My lord, may I take your lordship to the Honorable Chief Justice's order at page number
88.
88, my lords.
Because they are also, my lord, the averments made therein that on the basis of his patent right, he has come up before this court. And the court said that you are interested person. Because there are several orders passed in this High Court. So far, his patent right. My lord, the first interim order passed.
You are
They-
taking diametrically opposite stand in both the.
Then interim order.
No, my lords, my learned friend is misleading.
No, I am not misleading.
My lord, may I take your lordship to page number 86? The first writ was filed just on the basis of I'm making this submission at bar. If my learned friend can show a single averment that I'm making submission with regard to my patent in this writ petition.
Before the Honorable Chief Justice, you have
My lord,
claimed to be a patent holder.
No, my lord. In due deference of the learned single judge order, the learned single judge, what has been observed in page 86.
Let him. Let
My
him
lord, the
place-
court does not find.
Please take your seat. We'll call you.
My lord, the court does not find any specific grievance of the writ petition regarding violation of any legal right of them. It is incomprehensible as regard to the infringement of any fundamental or legal right of the petitioner due to inaction or illegal action on the part of state authority or its instrumentality. Rather, this court is of the opinion that grievance is at the best at the nature of public interest. So, my lord, what option being a citizen, I have been given by the court that your issue is of the public interest litigation. So I am because of this observation, I am duty bound to approach before the Honorable Chief Justice. The Honorable Chief Justice is of the view that I cannot hide that I am the patent holder. So I have informed the court that I am having the patent. The other contentious issue is pending. So Honorable Chief Justice wrote this order. So, my lord, I have never suppressed anything. And secondly, Chief Justice, Honorable Chief Justice, Division Bench of 2019, I was the intervener therein. The Chief Justice has been pleased to direct the state specifically that the plying of unregistered e-rickshaws is restricted until 2019. And I was the intervener.
Intervention.
And my lord,
Not the way, please. Yes.
my lord, may I take your lordship to page number 79? 78 is my name recorded.
See this order which is at page 88. This is an order in a proceeding I filed against the order passed by the court.
My lords. And my lord, 78 is the PIL court order in which I was the intervener. PIL was filed by somebody else.
After that order, you have come here.
My lords, I have gone before the learned single bench, and learned single bench has dismissed my writ petition, holding my patent right as false concocted, my lord. That's why I filed this appeal.
Once the honorable single judge was of the view that it was a case where you are required to file a PIL, the division bench says, no, it is not a PIL, you can espouse your cause as it is. Then you should have gone back to the single judge. Why?
My lord, I went to the single bench. Again, I went to the single bench, and learned single bench by impugned order, which is impugned in this appeal, has been pleased to dismiss my writ. At page number 90, my lords. My lord.
Department.
My lords. My lords. My lord, if your lordship so directs, I will produce the appeal copy also, my lords. ওই যে অ্যাপিলটা মেমো অফ অ্যাপিলটা ওই যেটা চিফের কাছে পড়েছিল আমরা হুম হুম স্যার আপনি কমপ্লেন্টার আপনার কাছ থেকে তো শিখেছি হুম হ্যাঁ। না না স্যার আরে মেন্টার স্যার এটা প্রফেশনাল মেন্টার আপনার কাছে আমি কি স্যার আরেকটা হুম
358 of 2024. Is it arising out of that WPA?
WPA P 358 of 2024.
Yes. Is it arising out of WPA 17687 of 2024?
No. WPA P 358 is was an independent proceeding.
My lord, it's arise out of the same proceeding. I am having the proof. If your lordship grants me 5 minutes time, I will bring the appeal copy. My- ওইটারই against কোর্ট ওটাই দেখতে চাইছে কোর্ট ওই অ্যাপিল দেখতে চাইছে
So the independent proceeding because of the fact that it's a separate proceeding.
স্যার ওটা বলছিল কপিটা এনে
দিলে
হ্যাঁ
হ্যাঁ আমার কাছে তো নেই
আমি কপিটা দিয়ে দেবো আপনাকে ডিসপোজাল করে থাকে
কবে করবে
মাইলেই করে দিচ্ছি
এই তোমাদের ফোন নাম্বারটা আছে তোমাদের ফোন নাম্বারটা আছে না হবে না
Grateful.
Number 31 কবে কবে কবে
Monday.
short passport, which you get phone number.
আচ্ছা আমি প্লেস করি তুমি আসুক দাদা আমি প্লেস করি একটু I am for the petitioner. No. Twice direction was given peremptorily today.
Last order 13 January 2025, your last indulgence, your lordship's order. Now present only one instruction, or lordship I am received. Only one instruction I am received, your lordship. But affidavit of which are not filed, your lordship kindly see the last instruction. 27 January 2025, your lordship.
ঠিক আছে ঠিক আছে
ওই জাজমেন্টটা দিয়েছিলাম না তোকে একটা, এটা অ্যামাউন্টস টু কন্টেম্পটের একটা। Now, নিলাম। Now, my lord, may I place my case? Well, so long you, sorry, sir. I,
Yes.
subject to sanction by your lordship. So long your lordship does not come heavily in this matter itself, they will not. Even after condonation has been done by the authority concerned, whether they can pass this order in not in consonance with the earlier verdict of the tribunal. Let me place. And another other your lordship directed me to bring the judgment regarding the doctrine of acta scuri nominem gavitat. Due to act of the court, whether petitioner can suffer. I have brought this. Now, kindly state away, kindly come to page 62. Petitioners were appointed in the post of lower division clerk in the office of the Register of Assurance. Selection process started 1995. But due to some court cases and stay proceedings, that process of selection could not have been continued. But after the vacation of that stay order or not a case of condonation, not a condonation, case of counting the past service. My lord. Not past service, appointment due to delayed proceedings in respect of that particular selection process. This is slightly difference of past service.
The period of delay.
But in respect of the petitioner number 1, only 7 months, 18 days.
No, that is the deficiency.
Deficiency.
What is the period of delay in appointment process?
Almost 14 years. 95 selection process, kindly take the note.
Yes.
Selection process again started 2006. Appointment given on 16 February 2009. These are the 3 crucial dates. And if we could have been appointed in the year 95 or 96, then our shortfall could not come.
Why it had to be done again in 2006?
Because of that vacation of the stay order or court proceedings came to be an end. That has been mentioned in page 62 itself. That is why thereafter I am placing. May I read for your lordship? In the type of giving, after giving appointment, my employer wrote a letter to the Inspector General, that approving authority itself. What happened there? May I read for your lordship, my lord? I would like to inform that the following candidates have been appointed in the vacant post LD clerks
in the Office of Registered Associations, Kolkata in 2008. The process of recruitment had started in the year 1995, but had to be deferred for court cases. Well, kindly see this. And imposition of embargo fresh recruitment. Finally, after the court case were vacated and the embargo was lifted, the process of appointment was completed and approval of the government. But in the meantime, 18 candidates has crossed and prescribed age limit of their first appointment. They have not noticing this, that we could not have been getting the pensionary benefit itself. I would therefore request to kindly condone the excess in age at the first appointment in respect of 18 candidates, detailing from annexure the copy of memorandum such and such, Register of Associations, Kolkata, while requisition of candidates were made to the employment exchange, and copies of sponsor letter exchange along with the condonation of age of 18 candidates are enclosed herewith. Now, my lord, kindly come to the next page.
You are amongst these 18.
Yes, serial number 10 and serial number 15. Now, the Inspector General not condone that. Whether after that condonation, now this letter subsists. Now I am reading. The appointment of 18 candidates have been made with the approval of the finance noted above, and all of them were within the prescribed age limit when the selection process of recruitment had started in the year 1995. But in excess of the age and at the same time, the cause due to court cases and imposition of the embargo on a fresh appointment. After careful consideration, matter in excess age over the prescribed limit of the above mentioned employees, he is hereby condoned. So, my lord, I leave you to lordship, nothing remains. Thereafter, what happened, I tell you, lordship. And my serial number to petitioner 10 and 15, kindly see. কবে কবে রিটায়ার করেছি ডেটটা বলতো? And my lord, kindly take 2 dates of our retirement.
There is the mention of 2006. You said something happened in 2006 also.
6 also. My lord, she started 6 and thereafter it has been appointed 8 and 9. In terms of the appointment letter also there. Appointment letter কত? Yes, বলছি.
The written test was conducted in 2006.
Yes, again, after the lifting of court cases.
Prior to 2006, what was the process that had been undertaken?
In the year 1995, it was undertaken, but there was no further proceedings.
95, the advertisement was issued.
Yes, initial recruitment. Call for the names from the employment exchange. Thereafter, yes.
Thereafter, there was an embargo.
Yes, there was an embargo.
After lifting of embargo in 2006, written test.
Again, written test and subsequent proceedings, remaining proceedings for giving appointment in the self-same selection process. ডেটটা কত কত বলতো? And from the list of dates, take 2 dates of retirement. Petitioner number 2 retired from 30th April 2016, and petitioner number 1 retired 30th June 2018. Now, thereafter, we made a representation before the authority concerned for pensionary benefit. The authority did not take care of. Now, it was forwarded to the authority at page 71. Kindly come to page 71. Page 71, my employer and secretary of the government of West Bengal made the forwarding letter of our representation to IGR.
Where is your representation?
Yes, representation at page 65. After retirement, mentioning internal page 68. the calculation thereof. Page 68. Now let kindly come to page 71. Page 71, authority also forwarded to the approving authority, taking consideration of the present situation.
প্রপোজাল পাঠাতে বললো এই পাঠাতে রয়েছে প্রপোজাল পাঠাতে বললো
এই তো 71 আছে তো।
21 last
Page 71, the undersigned forward herewith a copy of the order dated such and such for taking necessary action in the above noted subject for relaxation of age. Since no step was taken, the petitioner approached before the Honorable Tribunal. Page 81.
Where is the order passed in WPST 112?
My lord, I am pleasing. I am grateful. It is with me. I have made the compilation. My lord, kindly come to page 81.
Yes.
The tribunal, since no step was taken thereafter, my clients approached before the tribunal by filing the OA. May I read for your lordship? And after hearing of the learned advocates considering the facts, this application is disposed of, directing the respondent number register of assurance to dispose of the representation of the applicants as taking into para 11, 12, 14 of the judgment WPST.
That is why we said where is WPST 112?
But I'm anxious too, because they have not done anything thereafter. We have handed over the compilation. Yes, yes, and handed over to. Kindly come to the first judgments. I think your lordship got it. WST first page from page 1.
That is 112.
Yes, that the 112 and paragraph 8 onwards. My lord, kindly see. Similar set of facts. They are also delay 8 onwards.
But they have not considered this.
Page 83.
Wait.
Consider assurance.
Assurance considered this.
When the tribunal.
Send it to the approving authority again. After take that is why I am pressing the next pages.
Let us see what has happened after that.
Yes, no, that is there. After page 78, 71, the authority considered. I am giving that next page. 83, na? Okay. Yes, page 83. Consider the judgment and my lord approach before the authority concerned to give benefit of that judgment as well as pensionary benefit. Send it to the finance department. Page 85 is the my lord operative part.
The IG has the power to do this.
I think similarly, this is the appropriate authority, they are approving authority. Because they are sending thereafter also page 88 from the Inspector General to the Special Secretary.
IG has also.
IG has also, he's the upper authority of that. Page 88 also kindly sees. Or from one department to another department, they are giving the proposals for extending the benefit, but without any effective or implementation of that.
So there is no final rejection.
No final rejection. Since there are no final rejection, again representation, again tribunal held last order within periphery of rules.
Now they have come out with a rejection.
That is, kindly see the rejection. It is not in terms of the judgment of the Honorable Division Bench 112. Can they do this by bypassing that observation of the Honorable Court? Tantamount to contempt, I may say. Supreme Court says that justice of mockery otherwise. They should have. And we are waiting since 2018 onwards, 6 years. Delay is coming in that way. And there are your lordship judgment also in respect of.
Without sealing this letter, can you get any relief?
My lord?
Unless this order is sealed.
This order?
Yes.
Not subject to correction.
Now there is a final order rejecting your prayer. That is why we are thinking.
With great respect, I can, because this order is a nullity to that extent, it has not considered the very finding of the Honorable Division Bench order. And Honorable Supreme Court.
The Honorable Supreme Court says that order does not have nullity written on forehead. Be a declaration of its.
Your lordship has the power to set it aside itself. I can file a supplementary affidavit. They cannot do this.
Yes, it is challenged. That is why we are saying.
Your lordship, I can file a supplementary affidavit.
Has to be.
I can file a supplementary affidavit to bring it lordship's notice, because today I am getting. I can file a supplementary, or.
He has given it to you today. You take whatever steps you want. That is why we are
saying. Subject to correction. I am learning from, because this type of. Even it is a matter of just communication to your lordship.
No. This is written to the IG who has asked for the relaxation to be given.
Yes. Now it is from the Secretary of Government of West Bengal to the IGR. Now what says? Relaxation of shortfall pension of such and such, such and such.
It has not been communicated to you.
No.
This is an action taken on the representation forwarded by the office to the IG. Now IG has forwarded to the government. Government has taken a decision.
That is contrary to the initial observation.
That is.
May I make it by way of supplementary affidavit? Your lordship can in this petition itself, because they cannot. What is the decision of the Honorable Division Bench? I subject to correction.
That is all right.
And Honorable Supreme Court 2010 says, if there is a direction for consideration also, in the light of some periphery,
has to be done.
I am placing this by 1 week. Kindly give me time. Your lordship can set it aside, and there is no other option but to consider in that particular line.
You have communicated to him, how he will know about the order.
Just lordship order findings and then communicate to the IC. Your lordship send following the email. I take conclusion. This state government office is holiday, so I cannot contact anyone. Only receive this document. Nothing.
There is a holiday.
2 days. 2 days. 2 days holiday.
Yesterday also.
So I cannot contact the senior official.
জাজমেন্টটা কোথায় জানো? ওই জাজমেন্টটা অফ ওই জাজমেন্টটা Yes, your lordship. But in that fashion, they cannot bypass. 2016 and 18 retirement, now in the year 2025, after 9 years, old aged persons, your lordship, I have to file a supplementary affidavit or amendment application challenging this. Challenging. Let me give direction to file a application for appropriate order challenging this by amendment of the writ petition. It can be done. Well, I have seen at least 4 or 5 matters. They are bypassing for giving the pensionary benefit, taking the plea which is not extraneous. Only to bypass in that fashion. Legitimate expectation condoned by the upper authority. Whether there after anything or any predicament, I feel agony to that. Yet. Ready to.
In this matter, I am for the petitioner before your lordship. There is an application for restoration of the original writ petition. Kindly peruse the paragraph 10. My lord, this is my mistake. I am advocate on record. I could not reach the time due to misleading the list. অ্যাপ্লিকেশনটা দিয়েছেন দাদা? কেন অ্যাপ্লিকেশনটা দিয়েছেন? আমি তো ফাইল করেছি, এই দেখুন ফাইল।
The third dismissal in default.
My lord, due to my laches, my lord, I am due to accidentally COVID, I could not reach in time. Lands dispute on any others, my lord.
Earlier also neither.
I am a restoration. There is also restoration in original petition.
Case either there is no representation, adjournment or dismissal in default. This is the third dismissal.
No, my lord, there is some problem. I have malignant malaria, etc.
Address us on merits. What is the issue? Let us.
My lord, I have completed Public Service Commission, my lord, part 1 and part 2. And finally, I am selected as a LD assistant, Government of West Bengal. I have complied all the formalities. My lord, if your lordship peruse the page 35, original application, page 35, my lord, this is my appointment in the post of lower division clerk, subject to medical verification. I have complied all the formalities. Unfortunately, my lord, secondary school examination certificate from National Open School submitted by my client. They have claimed that it is not equivalent to the Madhyamik examination of the West Bengal secondary examination. On minimum examination, my marks contained in page 25, my lord. The certificate.
Yes.
My lord. My lord, I have kindly page 25. This is my certificate of the secondary examination from National Open Institution. I have successfully passed, and thereafter I have applied before the Public Service Commission West Bengal. I have completed part 1 and part 2 in all respect. Even my lord, medical examination has been complete. Thereafter, they have found that my qualification is not tally with the Madhyamik. My lord, your lordship knows very well the National Open Institution School Board and Madhyamik Board equivalent to the state level.
How do we know? From where do we know? You are saying we know very well. From where do we know? To us.
My lord. My lord, will your lordship kindly allow me one day? I will show that. Yes, my lord. My lord, what about restoration application, my lord?
Consider everything together.
My lord.
Monday.
Monday.
Merits.
Yes.
2003 matter.
My lord.
2003.
My lord.
What restoration? We'll hear you on the merits. Yes.
My lord. Can you Monday to Tuesday, my lord?
No, sir. Come on Monday, please.
Number 33. 33, I am for the petitioner. There is a
Lordship, in item number 33, I appear on behalf of the added respondent. Lordship.
there is a direction upon the state matter to file a report by way of an affidavit
Lordship.
on the last occasion, that is on 27th January. The matter where Chief Secretary was directed to consider the case of the petitioner by the dint of the order dated 16 June.
Already said that they have a report, so we ask them to place it on record.
Affidavit.
Yeah. Today, what can be?
Today resolution was there.
Not today.
Not today, not today.
Yes.
Oblige, Pandit.
Huh. 34. 34, I am for the petitioner.
Lordship, my senior is not present today.
Not required. He's here. We'll see. Yes,
Yes,
subsequent
last.
acquittal.
Yes, my lord.
Of a subsequent acquittal.
Yes, my last occasion, my lordship, to direct me to bring the judgment regarding this issue, the same facts of my lord, the criminal case acquittal, my lord, I bring the judgment, for judgment, my lord. Your lordship also suggested the Babulal and also my lord, other Anthony and
We did not suggest.
my lord,
Bulal will
substitute lordship correction, my lord, the judgment I have my lord, M. Pal Anthony, my lord, kindly. Yeah. Dada.
give a copy, then let her.
Yes.
They are, since they are already appearing, let them be here. Give copy.
Well,
Take down the citations. We are adjourning it, not today. Both sides will make their submission. Not today. Just take the job.
Babulal.
35.
My lord, another 3 judgment also, my lord. Yes.
Which Krishna? 34.
हाँ, 2 copy. मतलब I am giving the citation to the learned friend. Here. So one. Subject to lordship, one thing is the even the provident funds not has been released in this matter. Okay.
35. No, 35.
Item number 36.
35.
36, I'm appealing for the petitioner lordship. I'm praying fortnight adjournment. Pinaki Ranjan Chakraborty is the advocate on record. He is appointed as a Union of India, advocate for the Union of India. He is not in a position to appear against the Union of India. Due to that reason, he told me to pray for the fortnight adjournment. You want to give the no objection. ঠিক আছে 36 আমি অমল কুমার ব্যানার্জি আমার নাম
37.
Lord, I am for the petitioner.
Yes.
Can we come to page number 122, the input order, against which we have filed a review. The review application was rejected. Now, kindly come to the page 122, order dated 25/5/2012. Kindly come to,
You have filed a review against this order.
yes, but the review page, because that is not the proper ground for the review. If you have filed the, because kindly come to page, internal page 3 of the order, impute order 25/5/2012.
Yes.
Para 7. Admittedly, the applicant who had joined the railway services was given adverse ACR for the year ending 31st March 2022, which was communicated to the applicant by order dated 14/12/2002. The applicant submitted a representation appeal to the authority for review of the adverse ACR and also prayer for granting a promotion to the post of section engineer. After his expunging ACR, admittedly the applicant was served and communicated the adverse ACR. He was never been communicated about his work prior to the awarding the adverse ACR. But here is the minor impute order. The department has, prior to passing of ACR, department has several times warned the petitioner respondent that that there is an adverse remark against him and he should change his behavior, which he has not done. Now kindly come to the page 80, which is a reply submitted by the
page
80, which is a reply submitted by the Union of India before the Central Administrative Tribunal. Page 80 of the reply starts from page 72, the reply starts, and page 80 of the reply.
Yes.
Page para 15. With reference to the statement made in the paragraph 4.11 of the application, it is stated the applicant was warned several times before through the verbal and written warning, since of some of the events are furnished hereunder for the kind perusal. Letter dated issued to the applicant. Letter dated 21st 3rd 1995. 13/4/1995, 25/7/1995, 5/4/2001. These are the letters in view of the above. It is evident that before passing the adverse remark to the SCR, the applicant was warned several times to set right his behavior. So the impute order is bad in law for this reason. Because according to the impute order, the Union of India has never warned the respondent before passing the order. But the Union of India has several times informed the petitioner to change his behavior, which the petitioner has not done. And so the Union of India, the petitioner, was forced to pass an adverse remark at the ACR, and which consequently his promotion was demoted from his position. Now, the other reason for the passing of this order, which it was rejected, was apart from the Honorable Apex Court. Kindly come to the page, internal page 4 of the order. Impute order. Apart from the Honorable Apex Court in UP Jal Nigam versus Prabhat Chandra Jain, it is observed in the Honorable Apex Court, which is read as under the following. It was given an order now. Now come to the last, this page 5. No reason was mentioned in the order. Now the Honorable Lanet Trial Court Tribunal has rejected the petitioner's as per this order on the ground that there was no reason stated by the department while passing the order. The downgrading, when it comes at all the sometimes same the sting of the adverseness must in all event be not be reflected in such variation as otherwise they shall be communicated as such. It may be emphasized that even a positive confidential entry in a given case can previously be adverse, and to say that an adverse entry should always be quantitatively damaging may not be true. In the instant case, we have seen that the service record of the first respondent, no reason for the change is mentioned. Downgrading is reflected by comparison.
Was any rejoinder filed by them to the reply before the tribunal?
We have files in the trial. Page 84. They have not mentioned about the para 15. Page 84, the rejoinder still is from page 8. They never replied to the para 15, where we have stated that our numerous letters we have given. And
Those letters have you annexed?
No, it is not annexed. But the learned petitioner, the respondent has admitted that he has made some adverse remarks and because of his behavior is bad. Now come to page 35 and 36 of the petition. He has admitted. Page 35 to 36. Last para, page 36, last para. The respondent is writing, Amal Kumar Mahathur is writing the letter. I am the victim of the circumstances and I always protest over misdeeds, straightforward in my vision, and sincere, devoted, and full of integrity in my duty. That have become eyesore to my superiors, which is unfortunate for me. I therefore request your kind self to have my case reviewed for awarding natural justice so that I may not be denied of a legitimate promotion. I assure you, kind self, that this kind of appeal will not recur in future. I pray for your kind mercy in this regard, for which I always remain grateful to you. He has admitted that he will not do this kind of thing again.
Not for the relevant period.
He has not mentioned, but it is a review of the order of ACR when he has
Asking you, is it for the same period? Is it for the same year?
It is for the long gap he was misbehaving with his colleagues and everyone. For that reason, they have passed a ACR, adverse remark in the ACR, and for that reason, he has filed an appeal to it. Appeal for review of the CR.
This is not regarding the ACR which we are considering.
Yes, this is the regard to this ACR.
How do we find that it is for the same ACR?
Well, I'm coming to it.
Because this is for an ACR which has been written in 2002.
And our ACR is only 2002 ACR.
From this, where do we see 2000?
Why not come to the order?
Oh, come to page 35.
Appeal for review of my CR for consideration of a promotion against the restructuring. Page 35. When it come to the page 36, second para, that I went to meet the DI dash, I can't read it, in his chamber of, for, it has been written with type copies there. At the time he stopped smoking and cigarette, and this led to the issue adverse CR against me by this letter dated 14/12/2002. Page 55 to 56, petitioner has first a recent order against the respondent.
Page
55 to 56.
what is there?
This is a recent order passed by the petitioner. Because the previous order was cancelled, and then the Honorable Justice Kolanjyoti Sengupta had directed the petitioner to first a recent order. And the petitioner has first a recent order on 6/2/2008. That the recent order has not been passed, that allegation which has been raised in this order is not good.
It has been challenged in the OA.
It has been challenged in the OA. There is a judgment of Union of India versus PG Honorable Supreme. In which his Honorable Supreme Court has heard that in administrative order there is in adverse law there is no need of passing any.
There's no need of
Passing any reason. It's the judgment dated 1991, 23rd April. I have only one copy of it.
Say everything has been considered, so why do you?
Everything is, even if they say that there is no reason order has been passed, everything,
Stand
although we
that-
have passed a reason order.
Your stand is that we have given him 9 opportunities to
Yes,
rectify.
we have given him a 9
We have
opportunity.
communicated the reasons. We have heard him also after he has filed.
Yes,
them.
yes.
So why are you relying on that? No reason is required and no.
Yes, we have done it.
Yes. They have specifically enumerated the 9 letters that they have sent to you. There is no response in your rejoinder. You have chosen not to deny that. What is?
But Lordships, he being a handicapped person, continuously.
Can you use the mic, please? Yes.
Lordships, the petitioner being petitioner, no? Respondent petition. Respondent being a handicapped person, his colleagues all along Lordships irritated him, and that's why he stated in appeal Lordships.
Where's your appeal?
Rejoinder, not appeal. In rejoinder, he stated.
There are 2 grounds which you have taken. One is that you are not given opportunity to rectify.
Rectify himself.
And the other ground is that, of course, the other ground they are disputing that judgment will apply. Tribunal has gone on the ground that you are not allowed any opportunity to improve yourself.
Yes.
But they have given 9 opportunities. They have specifically enumerated with the letter number and dates. You have filed a rejoinder. You have chosen not to deny that. The rejoinder starts at page 84. Come to page 84. They have made specific averments in paragraph 15.
Lordship, he stated his disability is more than 52.5%.
Disability is not an issue. That's not the issue. Disability is not an issue. Issue is your alleged intemperate behavior. They say you are howling and shouting at all your superiors. They have given 9 instances that they have communicated to you. 2 letters in 95, 3 in 2001. Then this does not have any letter for the relevant period.
Let's finally come to the ACR. Page 29.
Page 29.
Yes, it's here. In the confidential report, page 29. In the confidential report for the year ending 31st March 2002, reviewed on remarks recorded as under. Now, 2002 they may not have given, but in last 6 or 7 years, the petitioner.
ACR means annual confidential report,
Annual
not career confidential.
Madam, he was continuously he misbehaved with the superiors. Continuously he misbehaved with the superior. They didn't pass an ACR on 1995 annual confidential report. They didn't pass in 95 or 96, 97. But 2002 they were supposed to do it. And moreover, he has admitted.
Yes, there are 2 more letters for that. Yeah. Yes, there are 2 letters. It's correct. What can be done? You neither responded nor you have said that you have not even denied or disputed this. judgment.
I have only one copy of it.
What is the citation?
It's not a citation, it's from the website of the.
Are you giving one copy?
My lord, I will give the citation. I will
Give us one copy. You are appearing.
I will give a citation.
Division bench, give us 2 copies.
I will give it to citation. But tomorrow, 17th and 18th, I will be busy in another show. Kindly keep it to 19th.
19th.
Kindly there be an order that has been hard.
Got 19th.
Item number 38.
Registration application. Registration application. My lord, on 27th January 2025, your lordship passed an order.
Yes.
Passed an order, my lord. The one application has been allowed and another application is pending.
Sir, for the petitioner.
For the petitioner. My lord, kindly see the order dated 27/11/2025 in the bottom portion, my lord.
Restoration.
This only can 3, my lord, the was not allowed, was not available in the file last occasion. That is, my lord, the.
Another restoration.
Yes.
Yes. So what, which paragraph? Can 3?
My lord, the file was not available.
Can 3 is not in the list.
Last occasion, it was not.
Yes, we are directed. Why? Let can 3 be taken up for consideration on 10th February. Why? Mr. Ali, it is not on list. Should we take it?
I was telling to Mr. Mukherjee.
Yes.
The court is doing injustice to us. He said, why? I told him, look, on Friday, nobody sits up 4:30. So you kindly pardon me, my.
Or
No, this matter is not. No, এটা নয়. আরে আমারটাই আমার.
All right, then not today because there is a resolution. Other side is not there. Let him be here. Get the can 3 listed on Matsumi.
হ্যাঁ ডিপার্টমেন্ট এখানে না এখানে না ডিপার্টমেন্টে ফাইল হয়েছে না আমি বলি তো আমি সাবমিশন রাখতে পারছি না
All the next things.
only not today.
Yes.
Not sure.
Item number 39.
My lord, 39, 40, 41. These three matters will be hard together. My lord, unfortunately, in the monthly list of March, because my lord, in the predicament, my lord, my client was coming to my chamber yesterday for a supplementary list. But from the way, he has to go to hospital. He is hospitalized. So I am in a very difficult situation. In the monthly list of March, and in the meantime, my lord, I will file
It
a
is to be exchanged or
No, until I get the copy of the supplementary affidavit.
April. What supplementary affidavit?
yes, supplementary
He wants
affidavit
to
I will
participate.
file. But in the meantime, I know, let it be in the meantime, I will file.
You will record an order that you will be filing a supplementary after serving a copy.
Yes.
Submitted by learned senior counsel.
Oh.
Submitted by learned senior